are so close to the end. Yeah. We are so close to the end. So let's just jump right in. I believe we left off, we were talking about definitions the last time. We made it through the definitions. And so now that puts us right at number 29, liquidated damages, which is nobody's favorite thing to talk about in the purchase agreement. But it's really important that we understand what liquidated damages is all about. So liquidated damages is about whether or not the seller can retain the buyer's deposit, right? So that's really important that we understand what we're talking about. I'm just playing with you guys. I'm kidding.
Are there some of yours out there too?
It's the same one of mine. You don't need it. We're going to speed straight through. So what I want you to remember about liquidated damages is if they sign the optional liquidated damages clause, then, you guys are making it really hard for me today, if they sign the optional liquidated damages clause, then if the property is 1 to 4 units, so those same armed guards will escort those of you out who are causing a ruckus here. You know that, right? If the property is between 1 and 4 units, then it cannot be more than the actual deposit or 3%, right? So when we first started, like on day 1, we talked about the deposit and we talked about what was a good number for the deposit. And you guys remember I said, well, it can't be any more than 3% because of liquidated damages. So here's where we get to that section of the contract. And I do remember like kind of flashing to that earlier when we talked about it. So I've got that, you guys remember that sign from math back in the day, like less than or greater than or whatever, the alligator's mouth and all that kind of stuff. So the retained, meaning what the seller can keep if the buyer defaults after removing contingencies, the most they can keep is either the deposit or 3%, whichever is less. So most of the time our deposits are going to be less than 3% because we know that. Sometimes they're around 2%. So that's the most that the seller can retain. So just wanted to get to that section. The other piece that I have on here for you guys is mediation. Oh, this is an important part. I almost forgot that part too. So a lot of times we know for a fact who should keep the deposit if the whole thing falls apart, right? Either they didn't remove contingencies and so it should go back to the buyer, or they did remove all their contingencies and it should go to the seller. And wouldn't it be fantastic if we were the ones who can say who gets the deposit? But unfortunately, it's not up to us. Even though it could be very clear in the contract who gets the deposit, it's either mutual consent, meaning both the buyer and seller sign off and agree, because that cancellation document has 2 sections. I feel like we talked about this. The first section just says, we're canceling, and that can be unilateral, meaning one side can say they're canceling if they have the right to in the contract. And then the second part of that cancellation document is what happens to the deposit. And so that piece has a place for 2 signatures. It has to be both the buyer and the seller. And so that's the mutual agreement. If they can't come to a mutual agreement, the money sits in escrow, and then either arbitration, if they elected arbitration, or a judicial decision, which oftentimes is small claims court, will have to decide what happens to that deposit. Now, what I normally tell agents in that situation is rather than have that money sit in escrow, that's a good time to begin to negotiate. And you might say, you know what, even though I know I should get the entire deposit, because I'm clearly right, how about we split it 50-50 or 60-40 or 70-30 or whatever it is that you come up with. And oftentimes, that's the easiest way to make sure that the escrow gets closed, resolved, and the deposit money is dispersed out. All right, you guys are good and quiet today. I like it. All right, mediation. So the only thing I want to touch on for you guys, mediation is not optional. It is in the contract as a requirement. And if you ever get into the situation where your clients call you up and they say, yep, we need mediation, circle, cut, clip, and send. You guys know that's my favorite thing to do. You've got the website right there where they can go and get the information they need to begin the mediation process. So it's right there in the mediation section. I highlighted it there for you, and you're just going to provide that information to your client so they can go ahead and get started with the mediation process. I feel like the principal's watching me while I'm doing this. Like, Don't tell on me, don't tell on me. All right, arbitration, yes.
And under the current liquidated damages clause, is that like the old one where it's exclusive to non-owner occupied, meaning if it's an investor, it doesn't apply?
It's 1 to 4 units. So if 1 to 4 occupied units, you're right, occupied units, yes. Arbitration. So arbitration is just, it is an optional section of the contract. Both parties do have to agree if you are going to arbitration. And if for one reason or another you have one party that agrees and the other party does not agree, that difference has to be resolved. And that can either be resolved by using the counteroffer. The language in the counteroffer already has that information, has that verbiage in there to resolve it. It says, unless otherwise agreed, any part that requires mutual agreement that is not mutually signed, I'm paraphrasing, is automatically removed, or you can add it in an addendum, but you can't have one person sign and the other person sign. You have to have complete agreement for arbitration and liquidated damages in the contract.
So if one of them signed it and the other one didn't, do you counter it, or what do you do?
You have to, you must either counter it or use an addendum to say what's going to happen.
For both liquidated and arbitration?
Yes, you can't have uneven signatures. Yes.
Most of the time I have seen seller signs it, but the buyer doesn't sign it.
Yeah.
Return it without signing it.
So the thing I would say is, hey, did you intend not to sign? Because sometimes it's like a DocuSign issue. The signature didn't show up, right? Or they missed it. They were signing at the bottom of every page and they didn't realize there were signatures required in the middle of the page. So just go back to them and say, hey, did you intentionally not sign? And most of the time, I'd say 95% of the time, they just missed it. But if they do not want it and the seller does, then you need to go back to the seller and say, do you want to get into an escrow with this person? They don't agree when it comes to liquidated damages, or they don't agree when it comes to arbitration.
Follow-up question, if buyer doesn't sign it, seller can stop not to proceed?
Correct. Correct, yeah. They have to agree. All right, we are closer and closer to the end.
One way or the other, they have to agree. They can both not want it.
Correct. Either they can both want it or they can both not want it, but they cannot not. It has to be agreement. All right, we are at the buyers signing off, saying that, yep, everything on these, 102 pages now, this purchase agreement? Everything on this 102 pages we agree to, this is what we want it to be, and so this is where the buyer would sign off. We used to use a form, and we still do use a form called the Representative Capacity Addendum whenever you had what we call an entity buyer, meaning it's a trust, or it's an LLC, or power of attorney, which doesn't really ever work out. But now they've built it into the purchase agreement. So if the seller is a trust, if the buyer is a trust or an LLC, they can go ahead and document that entity relationship right there on section 32B. Check the box and fill it out. And there's a section for them to put their entity, right, who they are, the trust, the living trust of Talisa Belam and family. And then the authorized signer is going to be the person for that trust who is authorized to sign. And when they put that name in there, that means that every time they sign on any of the documents, they can sign their name because they've already matched it up and said, whenever you see the trust, and you know that Talisa Belam is the authorized signer for that trust. So when you see Talisa Belam and she's signing, she's actually signing as Talisa Belam, whatever name I made up, right? So that's what allows us to do that right there in the purchase agreement. And if you do it up front in the purchase agreement, you do not have to have the representative capacity agreement or the RCSD. You only need the RCSD if you didn't do it in the purchase agreement and they decide later on for whatever reason or something comes up, you didn't realize they were in a trust, then you need to go back and use that document, that addendum, to add that into the purchase agreement. Yes?
Would you add the actual trust document with the offer then?
the trust advisory.
Or whatever, whatever it is.
Yeah.
Because they need to see that you're actually who you are, right?
Oh, the documentation for the trust? You don't usually share that type of documentation across from the buyer to the seller. You normally let escrow handle that. So escrow would have that documentation, and they would verify that the signer is correct, evidence of authority to act. And so they would just make sure that the names matched up. And we just take our cues from escrow. If escrow and title says that it's okay, then that's the purpose of title, to verify.
So escrow will verify it with the person who is signing on behalf of the trust, is really is a trust.
Yes.
Escrow will ask, oh, you have anything you need to show.
They need to see evidence. Escrow needs to see evidence, yes. All right. Now, there's a new part of the, oh wait, I'm not there yet. Okay, so that's that. Am I clicking the wrong thing? Okay. So now it's the seller's turn to decide if these 102 pages and everything that the buyer has presented is something that they want to move forward on. And there's also a section for the seller, in case the seller's property is in a trust, they can also sign as an entity seller as well. So that's that section on the bottom. But the seller has the option to either accept the offer in full and say, yay, we're in escrow, we agree to everything. You know, nice when that happens. Or they could check the box saying that there's going to be a counter offer and the seller's going to counter some of the terms. They can also say, we will put you in backup. So we like your offer, but there's one that we like better than yours, and you're going to go in backup position. And that's formal backup position, meaning that if the initial offer falls out, then they're automatically put in first position. So that's really cool, because a lot of times we talk about, let me just kind of move forward, because I think I have my backup offer next. A lot of times we talk about going in backup position, but we don't actually have the backup addendum signed. So it just means that they kind of promise, well, if things don't work out, I'll call you. That's not the same as being in a formal backup position. When you're in a formal backup position and you have the backup addendum signed, as I said, as soon as that initial escrow falls out, they don't get to go back on the market. They don't get to call anybody. You're automatically in place. So another thing to think about that, if you're the listing agent and you're taking a backup offer, before you accept the backup offer as backup, you want to work out any of the terms that you don't like. So you may be negotiating with a backup offer, even a counter, knowing that they're going to be in backup position, because once again, once you sign that backup offer addendum, they are automatically in first place. The negotiations have already been done, solved. It's a done deal, right?
So
You guys with me on that?
So before accepting the backup, you have to make sure seller and buyer agree on every term.
Yes, yes, because they're,
Because if one, first offer fails, we again dispute, so it is better.
there will not be a dispute. It'll be whatever you agree to. So there is, once they sign the backup offer addendum, they are in contract with you under those terms. So you can't come back later and say, well, I've been escrow for 30 days and the price has gone up, and now I want you to, no. Once you accept it, you accepted the backup offer addendum. Okay? Let's see. Why do I have a blank page there? So the seller can do a counter offer, take a backup offer, or actually sign. I talked about them being an entity buyer, and then they sign. What do I have next? Let's talk about counter offers. This is almost literally the last thing I have to talk to you guys about, I promise. Okay, so there's two types of counter offers. There's the regular counter offer, which is the SCO, and then there's the multiple counter offer, which is the SMCO, M standing for multiple. They're dealt with differently. When you have a counter out and it's just a regular counter offer, the minute the other party signs that counter, you're in escrow. It's a done deal. It's a wrap. You don't have any time to think about it after that. The seller says, I counter you these terms. The buyer signs, it's done. We're together. If the buyer were to say, I like everything on your counter, Mr. Seller, but there's one more thing that I want to see changed, they would come back with a buyer counter to the seller's counter. I know, it's kind of like the RR and the RRRR, right? So they would come back with the buyer's counter. But the thing to think about whenever you're doing that is at given time, while you're countering back and forth, a new buyer could come in and write an offer that's clean, and they can accept that offer. Before you have that agreement where the signatures are done and it's a done deal, it's up in the air. So I always recommend pick up the phone, work out the terms, come to an agreement, and then get it on paper as soon as possible and get all the signatures on it. Because as you're shuffling paper back and forth, somebody else could easily come in, and you can best believe the listing agent's going to tell whoever the next buyer is, these are the terms that I'm countering right now. So if you come in clean, we can get in your countering. It's still an open playing field. The multiple counteroffer is even more open because in the multiple counteroffer, I think I have one up here, there's a whole nother section which is called the binding effect. So the way the multiple counter works is the seller counters 2, 3, 5 buyers, and those 5 buyers, or however many, reply back. And then the seller looks at the replies that they received and decides which one they're going to pick. So when you reply back as a buyer, you still have to wait and hope that you're the one who's selected. Or they can say, I don't want any of these. I'm not doing anything with any of them, and not accept any of them. So sometimes you'll see on a multiple counter, highest and best, right? And then we go, oh, what does that mean? I did my highest and best. But they're basically saying, raise the stakes, everybody. Just go for it, right? But we already talked about it in this market. We've already went for it. We already left nothing out. But, you know, that's when you have to really just dig deep, call relatives, whatever it is, right? Because you just want to go a little bit higher to beat the next offer. So, I mean, everybody hates those highest and best. You're like, what is it going to take? I already gave you my kids. So I really think when you're getting a multiple counteroffer, you might even choose to raise the stakes if you can. If you have anything left in your coffers, you know what I mean? There's no reason why, if you know they're making a multiple counter out to many, they're usually evening it up if you don't get that highest and best. If you get terms, maybe if you just went an inch higher than the terms that they put out there, then maybe you'd be higher than all the counters. Because usually, don't you think that when you're putting out a multiple counter, you're kind of making everybody even so you can see which one rises to the occasion? Maybe you would take a step forward and be the one that kind of stands out more than the rest. So just thinking about that, when you have a multiple counter, everybody's got even playing field again, and they have to make a decision. Now, I had one yesterday where an agent called me and said, I have 3 offers. One of them's kind of the best. Can I just counter those other 2 to bring those kind of to where the first one is? You can, but you need to be careful of, like, could there potentially be a fair housing violation? You always want to be thinking about that in the back of your mind too, right? Your conduct, whenever you're dealing with potential clients, you need to be, we talked about this in the beginning, doing the same thing across the board, right? You can't have a special script for this person and a special script for that person. So just think about that in all of your duties and behaviors and acts. You want to kind of act the same along the way. But I don't know, we can ask the legal team if that's illegal to just counter a couple and not counter the other one. You can tell us. Okay, all right.
Wouldn't you get a better, like if you did all 3, because that one doesn't know they're the best, so you might just get a slightly little bit better offer on that third one too.
So our duty is always to do the best thing for our client. So that's ultimately what our decision needs to be. Like, how do I best serve my client? And if for whatever reason the agent felt that it was best to serve her client by doing whatever, you know, I see all kind of crazy things. So, but just know that unfortunately you don't necessarily know what's going on behind the multiple counters, but you do know that you're not the only one who's being countered, and so you want to just put your best foot forward always. And okay, that's it, you guys. I am getting out of your way because the last thing that there is the buyer's investigation advisory, right? And so the buyer's investigation advisory is the final document in the purchase packet, and that document just tells the buyer, hey, you're advised to get these inspections, and it's up to your buyer to decide which of those inspections they choose to get, right? But they're being advised of all these inspections that are out there. So That is the entire purchase packet. You are welcome. I am so glad that I don't have to see you guys next Friday. No, I'm kidding. All right, so are you guys like announcing yourselves and doing your?
Yeah, we'll introduce ourselves.
Okay.
I'll make the story up as we go.
I'm kidding. This was so much fun for me to be able to come out and do this with you guys for the month of March. So thank you so much for putting up with me. I'm just sitting back and learn with you guys. Do you want me to turn this mic off, or are you going to be using it?
Yeah, we can just do the handouts.
Testing, testing.
Testing. I don't know. I wear hearing aids, so I can't hear.
Check, check.
You ready? Test. All right. Oh, look at this. The platform again. Woo! How you guys doing? Sometimes I feel like it's a comedy routine when I get up here because I have so much fun. It is good to be back in PCAR. COVID shut this whole thing down, and for 2 years we were doing everything by Zoom. And for you guys that was great, but for me I couldn't tell when you were getting bored. Actually, I knew what was happening is all your nice shiny faces would be on the screen, and then when I started going long, they would start to go to black, or they would go to pictures, or people just disconnect. No, it is great. My name is Keith Dunnigan. For those of you who don't know me, I'm the managing shareholder of BPE Law Group. We've been working with real estate agents for a long time. This is my friend Trey Van Dyke.
Hello.
Trey is a second-year law student. He's the smart one. I'm the funny one. I've been doing this long enough that I have stories, because I think stories help us learn. And so we're going to talk through. Trey's going to walk us through a little bit of the RPA. You guys have already gotten a great class for the last 4 weeks, so you know this. So a little bit of this is going to be review. But then we're going to get into kind of what don't we want to do? How do we protect ourselves? Where are these pitfalls? One of the things that Talisa started with, which I think was great, the definitions. How many of you have actually read the definition section? There's not enough hands up. How many have read the definitions? If you haven't, here's your homework. Over the weekend, read them. One of the most important definitions that you need to understand is how to count days. There's a big section in there. It's about 12 lines long. And the reason it's important is you have to understand, when we get into contract, when is the first day? Is it the day that we sign? Is it the next day? When is it? Well, if you read the definitions and you understand that it's the first full day after execution. That's when it starts. But then you have to think about performance, like contingencies and when they have to be released. When do they end? When do we get to exercising rights, right? Well, if it's a 17-day contingency window and that 17th day runs on Sunday, does it end on that Sunday? Yes or no? Good. Somebody was listening to you. This is fantastic. No. It runs over to the next business day. Now, the problem is what if that next business day isn't Monday? It's Tuesday. Then you run over. And a lot of people mess this up because what they'll do is they'll go, I'm going to get a little sneaky, and I'm going to send my notice to perform. That's 2 days on a Friday. Please don't do that, because all you've done is just given somebody a third day. Because if you send it on a Friday, Saturday is the first full day, Sunday's the second day. Oh, nope. Sunday doesn't count. You've given them Monday. So you got to be thinking strategically when you're representing your clients on how is this going to work? Where are these timelines going to line up so that we understand that we can take advantage and put the documents into place at the right time. Now, that's a little bit of a segue, and I'm going to let Trey start out by getting us through the purchase agreement real quickly.
All right. I know you've gone over the RPA in depth, so we'll kind of go through this section pretty quickly because we usually have at least half of the people haven't even seen the new one yet, but you guys are experts, so we'll kind of go through this a little quicker. First, we'll just talk about how the whole thing shuffled up, some changes that we want to point out, and then we'll turn it over to Keith for the biggest potential pitfalls and some best practices, which I know is what you really all want to hear. So, as you all know, the old sections, everybody's comfortable and familiar with these, and then Carr decided to just break everything up. And if there's any billiard fans out there, I apologize. I know there's not a 25 or a 27 ball, but just use your imagination for a second. So these are where all the different sections went. The green check marks show that those remain the same. Definitely all shuffled around. And there's a few that were expanded. For example, 22 was dispute resolution on the old RPA, and because there were so many important things in that one section, they did the wise thing of splitting it up into 30 and 31, which is arbitration and mediation, and we'll go into that.
There was a reason why they split it up. How many of you have had a deal go bad where the buyer and seller don't like each other? You guys are fortunate. Either you're really good, or I'll just stop there. It happens, and what we were seeing is, a lot of times there would be the mediation provision, the arbitration provision was stacked up, and they wouldn't execute or initial that arbitration provision. And the party who was doing the bad stuff would get that, that letter that said, hey, you're doing something bad, we need to mediate. And when it was creating confusion, because people were coming back and saying, hey, I didn't sign the arbitration provision, so therefore I don't have to mediate. Let's just deal with this. That's not what the document said. What the document said before this one is, even though you had paragraph A and paragraph B, which was the mediation arbitration, mediation still had a line in it that said that even if you don't sign the arbitration clause, you don't initial it, you are still bound to mediate. So we were seeing all of this confusion begin to happen related to consumers. And it became apparent that, well, the easiest way to make that confusion go away was to split them up. And so that's what Carr did. And we talked a lot about this. I participate with the Carr Legal Affiliates Forum. And we talk a lot about this stuff in the trainings that they do about how to make these things happen. And that was one of the issues that we kept seeing coming up, is how do we deal with this? It makes it simple, and it's a good thing to understand, because now, as your clients are getting into their transaction, hopefully they're looking past page 4 and the table, and understanding that these terms now are broken up so that you can see that individual obligation.
So, as you know, the law did change. Cosmetically, definitely, it looks completely different, the new RPA. And a lot of that is that, obviously, they put, as Keith just alluded to, they put all the changeable terms, all your blue ink and zip form terms into that one big table at the beginning. But what's really important, and we're definitely going to hit on this several times throughout this presentation, is that even though all those changeable terms up front, are up front, which is great for the consumer because they can kind of see everything right up front. You can't miss anything, like a deadline that's buried deep inside all the black ink. But what's important is that all that black ink that's at 9-point font, that's at the end, is actually the legally binding language. So even though it's a really nice presentation on starting on page 3 with the table, the thing that's actually binding the parties is the rest of the contract. Very familiar. I know you guys have seen this so many times. But just a couple things we do want to point out on here. So this is on section 3, the big table. Does this have a laser? Yes, awesome. I'll try not to be crazy with this laser in my hand. I know the power I wield.
This is no.
So I want to just point out on row D here, which corresponds to section 5A1 in the RPA, the deposit amount. So there's this weird conundrum here. When you type on zip forms, it automatically populates the percentage. And so this is causes a little bit of problems in escrow because although this is automatic here, right, and so it's great, we don't have to do the math because it does that for us, which I'm terrible at math, so this is really nice. But when the parties go to counter and the purchase price changes, that percentage is going to be off. And so now when escrow has the contract and the signed counteroffer and with a different purchase price, you know, do they go off of the 1% here, or do they go off of, you know, what was the original dollar amount? So a good thing to just kind of prevent any issues from that is to, on the counters, make sure that also the new deposit price is reflected, if that's a change, or at least understood. Because otherwise, escrow, as a fiduciary to both parties, they're going to have to get written consent from both parties if and escrow is going to say, well, which is it? Because this percentage no longer reflects this number because that purchase price changed. Does that make sense? Yeah, it's the other way. Yeah, in zip forms, when you enter this right here, yeah, it'll auto-populate that, which is really nice and convenient, but it does present this issue in escrow, right? Because if the in the counter, it's not explicit what that new deposit amount is going to be. And then one last thing we want to hit on over here with wire transfer. So obviously you can see on here the default is wire transfer. And if your client has any inclination that they're going to use something else, it's good to put that here because otherwise it's going to have written consent from both parties, right? Just like I said before for the deposit amount, because if it says wire transfer and they want to have a cashier's check, it's going to have written consent from both sides. So that's just going to cause a further delay. Now, there is a provision in 5A1 that says if escrow is unable to accept whatever payment is here, right? If you want to put Bitcoin in here, and escrow's like, nope, sorry, or Dogecoin, or whatever your coin of choice is, and escrow's like, no, sorry, that's not going to work. The default in 5A1 says that back to wire transfer, right? So if whatever you put here doesn't work and escrow can't take it, it's already written in there that wire transfer is fine, and that's the default. Yeah. Yeah, something simple as that would be perfect, and then escrow should be able to understand that. Well, and that's kind of the conundrum. So escrow would just be, they would just have their hands in the air, right? Because it says two different things. And so they would have to get explicit permission from both sides as to, well, what's the deposit going to be? Because they're a fiduciary to both sides. So it would just delay it, you know, then now you're pressing on deadlines and stuff, so.
That's always the easiest thing. The problem is the way this is auto-populating, it creates an issue. And so when that got set up in forms, you stick the percentage in. I think it populates the number. If you stick the number in, it populates the percentage.
No, actually, it's only one way.
Only one way?
So you're only allowed to put this in.
Perfect.
Yeah. You're only allowed to put the actual
Number in?
yeah.
Yeah.
No, that's just it's just an auto thing. But it's still going to be on the contract.
I'll mention that to some people.
So, yeah.
So here's the problem with that. Here's the problem with that from a judicial interpretation. When they did that, you can see where it says the percentage of the purchase price. They closed that as its own term. Then they created a separate term. And so those two brackets, the way they're set up from a judicial interpretation problem, it creates ambiguity. That's the problem. I don't know. Have you tried that?
So just leave this blank?
No.
Uh-huh. It's not a field you can edit the percentage. No, it's part of the form. Yeah, unfortunately. Okay, nice. I haven't heard that. Okay, thank you for that. I haven't heard that.
One other thing to think about with this, when you look at the buyer and seller,
She said that it's not on.
Yep.
Okay, she said, just for everyone, if you're using SkySlope, she said that it doesn't auto-populate. So you might be able to put whatever's in there. I've only just seen it on zip forms where the percentage is uneditable. Yeah, I'm not suggesting that. No suggestion on using SkySlope or any other party, just an observation.
Yeah. One thing to be thinking about, because oftentimes when you get into purchase and sales contracts, you have the buyer and the seller. How many of you work with first-time home buyers? In this market, how many are you seeing where mom and dad are having to help the first-time home buyer with a deposit? How many of you are putting in a term that allows mom and dad to make that deposit into escrow? So one of the things you want to be thinking about is if you have a buyer and a seller, and you have a third party who's going to make that deposit, escrow needs an instruction for that. So you want to be upfront on that. Put that in an additional terms provision. Put that somewhere in the agreement, because otherwise, if mom and dad show up to make that deposit, they're going to go into escrow. Escrow is going to have the contract. They're going to get the check, and they're going to go, I don't know who you are. I don't know who you are. And because I don't know who you are, I can't accept this. And so that just slows the process down. So be thinking a couple steps ahead when you're working with these buyers and sellers on the way that initial deposit's going to work. Just an additional terms provision. Well, gift money, that's for a lender. That's not for escrow. That's for lenders.
All right, here's some just some key changes we want to point out. I know you've probably been introduced to a lot of changes step by step, and that's great. And so if some of this is repetitive, I apologize. We want to point out that there's several reminders in the new RPA to read all 16 pages, which is important because, like what we talked about, it's great for the consumer that everything's in this nice, neat table, but the actual binding language is everything after it. So. And we'll touch on that as one of the pitfalls, is just make sure your clients are reading all 16 pages. And also, there's a wording in there, removal or waiver of contingencies at time of offers against agent advice, which is probably something that is a reflection of the current market that we find ourselves in. But that's really important. We want to make sure that that's kind of a CYB in there to make sure that that's at least said in here that this is not the right, maybe not a good thing to do. But
one of the legal things to think about is we've probably all seen these situations where people are trying to be hyper competitive, so they're removing their contingencies before they get into contract or at the time they get into contract. One of the things that's creating problems now is there's a statute that kind of speaks a little bit to this. It's 1102.3 of the Civil Code. And what happens in that statute, you get into a contract. So let's say Trey and I are selling. And Trey is selling to me, and I'm going to buy, and I waive my contingencies. We enter into the contract, boom, we're good to go. One day later, he hands me his transfer disclosure statement. Do I have any contingencies to look at that and make decisions on whether or not I want to get out? If you think if you think it's yes, raise your hand. 4 of you or 5 of you are right. 1102.3 says that if there's any disclosure or a material amendment that is given after the time that the parties enter into a contract, if it's delivered personally, the buyer has 3 days to review it and cancel the agreement. If it's given to them electronically, DocuSign, anybody say? Disclosure comes the day later, they've just given people contingencies. And it's creating a fight. And so one of the ways to avoid that is at least have a little bit of a contingency, or at least have the clients advised both the seller and the buyer advised that, well, this is the way it really happens, so you can have this waiver, but if you change your disclosures, or if you give a new one, or if you amend them, you revive them, things that need to be understood.
Sorry, Keith, I forgot that the foundation was broke and half the house is sliding down a hill.
I'm going to cancel. Or we can write it down 150 grand.
So a couple other things we wanted to point out here. In the items included and excluded, smart system devices is added in there, and also that the seller must cooperate with buyer's efforts to transfer any software as a part of that, and that's just kind of an update on the smart home features and stuff that people have in their houses. Notice to perform for buyer and sellers consolidated into one paragraph, and I think you've probably been introduced to the most of these, so we'll press on. So now to the main event, the biggest potential pitfalls and best practices.
Well, thank you. Before I get into this, I wanted to talk about the one issue that is it Talisa? That's my cousin's name. Fantastic. She's my cousin. I don't know. No, I wanted to talk about the HUD issue and the fair housing. So you had that question from a legal standpoint. You've got 3 offers. One offer is really good, and you got 2 that you want to counter. Do you counter only the 2 and leave the 1 in place? The answer is no. And you were absolutely right. It gets to fair housing because now what you're functionally doing is you're not treating all the parties the same. That's the problem. I had this case about a year and a half ago. My client had a really good offer, $2.2 million on a nice piece of property, all cash. 10-day close. No contingencies. We're going to win. We didn't win. What the seller did is the seller countered back to a couple other people. My client, who was working with a very good agent, did everything by the book. No family letter, no pictures, all cash offer, very strong. The 2 people who got countered back had lower offers. They used family pictures. Whoops. So functionally what happened is because of the scenario that was created, my client was in first place, was going to get the property. But what happened is these other people on that countered back with better terms and a better price. That raised functionally a discrimination claim because the person who was in first place, they did exactly what you're thinking. We just want to try and get an agreement or another offer up to this one to make the determination. But they had all of these other factors in place. So one of the things you don't know, especially if you're the buyer's agent, you don't know what the other buyers are submitting. You don't know what that other information is going to be. If you're the listing agent, don't put yourself in that position. You've got 3 offers that you like, and you know you want to counter 2 of them back. Counter all 3 of them. That way, nobody can raise a claim. So we lit a fire under a brokerage on that one, and we got it worked out. My client still didn't get the property because at the end of the day, people came up with more money, and my client wasn't willing to go up. But we had to work through that problem. So you want to deal with those issues. Treat everybody the same. That way, we don't have to deal with discrimination claims because that's not only a legal issue, it's a licensing issue. So, yes. We had an unsophisticated agent that let it slip. Whoops. Okay. Unlicensed practice of law. How many of you know what that is? How many of you engage in it on a daily basis? How many of you don't know if you do it? The people who raise their hand on the don't know, they're the ones that are telling the truth. No, this is an important one So as a licensed professional, there are things that you have the right to do. Ministerial acts. Think about ministerial acts. Those things like filling out forms, passing information along. Those are allowed. Drawing legal conclusions are not allowed. One of the things to think about, where do you think, and this has been a trick question, I've been asking this question to every group that I talk to, where do you think is the number one place that an agent gets themselves in trouble with on unlicensed practice of law? TDS, maybe. Not the number one, though. Avid, no, because that's just your investigation.
Can I give them a hint?
You can give them a hint.
Okay, it comes in. A lot of times it comes in before it hits the market, right? Something that the listing agent is doing ahead of time. Not always, but it's part of
The title company. Preliminary title. Anybody say preliminary title report? Did you? Preliminary title report. When you represent the buyer, that preliminary title report comes in. And you know, you got Schedule A that's like, this is the person that owns it, this is blah, blah, blah. And then you've got Schedule B. And Schedule B, like the first one makes sense. You have to pay property taxes, and they're calculated by X. And you have to, in some properties and others not, Melrose, and this is what it is. And then it gets down to easements, rights of way, utility setbacks. And that buyer begins to go, what does this mean? You know, normally, like if you're in one of these suburbs in an urban setting, it's not that big of a deal. But when you get in, and we see this a lot in the rural communities, because they have shared road maintenance agreements. And the buyer goes, I see that there's a shared road maintenance agreement. What does that mean? This is where the Twilight music, that Twilight Zone music should be playing right now. That's the problem. Because now what you're getting into is you have a restrictive covenant that affects the land that has a legal implication. Some of that legal implication may be on how do they calculate percentages of the shared cost. Do they have lien rights? How do they make the determination on how to do an improvement? Can they do an improvement without my consent? Maybe, maybe not. Requires somebody to read the agreement and make a determination. And so be very, very careful. When you hear that question, what does this mean? What is the impact? What is my risk? Those are now getting you into situations where it's requiring you to draw a legal conclusion. And there's a problem with that. Normally, I'd say your biggest problem is, well, you violate the law and it's a misdemeanor, you know. And I tell this little story. You go, you got to think about it. Lawyers protect their own. The assembly is made up. Anybody in here related to somebody in the assembly before I say something? The assembly is typically made up of lawyers who no longer practice for one reason or another. The prosecutors who enforce the laws that are passed by the assembly, they're all lawyers. The defense attorney who's going to defend you is a lawyer. Now, come on, that's a conflict of interest, right? They're protecting their business from something that somebody else did. I don't get it. And more importantly, the judge who makes the decision, retired lawyer. We do a pretty good job protecting our own. And now you all hate lawyers. It's okay, you're in good company, so do I. It's a conundrum. No, but you want to be thinking about this, is because of the way this is set up, it's very easy in these transactions to unintentionally cross the line. I'm not worried about the misdemeanor charge. There's like 11 people in the entire state of California in jail for unlicensed practice of law, and they did really, really stupid stuff. Your bigger problem is insurance. How many of you know what E&O is? I know there's a couple of you in here that I see that know what it is and deal with it regularly. Your E&O insurance most of the time will have a carve-out that says that if you intentionally violate a statute or if you break a criminal law, your E&O may not cover you. So your biggest problem that you got to be thinking about is as you're walking down this process, because we all want to give our clients great service, right? We don't want to tell our client that, well, for this easy question that I know the answer to, you actually have to go talk to a lawyer and spend a lot of money. You don't want to do that. You have to be careful because if you get the wrong answer and then that client brings a negligence claim, you may not have the coverage on the E&O. And that's really your big risk, is watching out for that compliance with that E&O. We want to make sure we take care of that. So really be thinking about that one question. What's my risk? What's my liability? What does this mean? When people start handing that stuff to you and they make those questions, that's when you need to be going, I think you should talk to somebody who can give you the answer. We'd love to give it to you. We're just not allowed to. Breach of fiduciary duties. This one goes without saying. One of the things that you have, and it's really great that you guys have spent 4 weeks learning about this RPA, because one of the things you have is the duty of reasonable care. Do you know what the standard is for the reasonable care? Anybody? Oh, no, that's a fiduciary duty. That's not the standard of care. Nice try. Close. That's the general negligence standard. We're getting there. Not quite there. The standard of care for a real estate professional is the same care that somebody in the same profession, in the same or similar locale, would exert in this situation. So it's what Bob would do. I'm just using it as an example. That's what it is. And so the way these things play out, when you have that duty of reasonable care, you have that duty that is what a person in a similarly situated profession, in a similarly situated locale, what they would do. And the first thing they're going to do to ask to testify is your competitor. And so one of the things you have to be thinking, the reason it's important from a standard of care is understanding that contract. You guys have all been great. You've sat through 4 hours of this now? 5 hours? A lot more? Woo! You guys are better than me. A lot of people aren't sitting through these classes. They aren't taking the time to learn the contract. And reasonable care would require you to spend the time to understand the second is going to talk about DocuSign and some of that stuff. You have a duty to investigate and disclose. That's in your TDS and your AVID. You know, working with the client through the TDS. You don't tell them how to write it out. You tell them, here's the question. How do you answer it? I'm going to step back so I don't fall off. You tell them, this is the question, and you need to answer it, and answer it in your own language. You have a duty to investigate. Notice it doesn't say you have a duty to inspect. There's a difference. If you inspect, that means you're going in deeper than normally. You're opening cupboards, you're checking water lines, you're doing, no, don't do that. Because the problem is you've increased your liability on your fiduciary responsibility. So you need to do that visual inspection or the visual investigation. Slap me next time I say the word inspection. It's not okay.
I'll shine the laser at you.
Shine the laser at me. And make sure that information gets passed. Brokers have a duty to supervise. What does that mean? I mean, let's be realistic. There's so many transactions going on. It's so fast. You can't look at everything. It's having the right training and the right oversight in place to make sure that agents are performing their obligations under their agreements.
We talked about this a little bit.
You want to start?
Sure. So as we talked about before, the new table format is great for consumers, but it does present some challenges, right? Especially when what we just talked about, the fiduciary duty and that reasonable care. And, making, and part of that reasonable duty is making sure that the client understands the contract, right, that they're signing. So what's something you think agents use pretty much every day that could present an issue here? DocuSign. Yep. You love it, but you love to hate it. So yeah, DocuSign on here, like how many times, do people click next, 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 sign? So something interesting to think about that, if a judge is looking at a case and a suit, and they're reading that timestamp on DocuSign, and it says it was sent to them 11:59, opened at 12, and signed and returned at 12:03. Do you think they read all 16 pages in 3 minutes? Keith has probably read the RPA like 2,000 times, and I don't think he could read it in 3 minutes.
No, I've read that a lot. More than my head cares to remember. No, but the problem we run into, so the law says that when you enter into a contract, the parties that enter the contract and are bound to it are presumed is a terrible word, presumed to have read and understood the agreement. You know what the problem with a presumption is? It can be rebutted. You can show that it didn't happen. And you know who's really good at showing it doesn't happen? DocuSign. I love DocuSign. I use it. I think it's great. But I think it has to be used in the right context. Because what happens with DocuSign, as Trey says, is you send it at 11:59. It opens at midnight or noon or whatever. Maybe somebody's staying up late. I don't know. And then it's signed at 12:03 and returned back. The judge, who's going to get this, it's going to come to them. And it's going to have that signature page. And it's going to have all of the transaction pages in there. And the judge is going to look at this. And the very fine and scholarly and learned individual sitting on the bench is going to look at this and go, 16 pages of type 9 font. How in the world did somebody read this in 3 minutes? I'm a smart individual. I read fast. I went to law school. I passed a bar exam. I've had to do this for a very long time. I can't read that fast. I don't know what it says. So it begins to become very easy to overcome that presumption. So part of this gets back to understanding and reading that agreement, also gets back to your fiduciary obligation on making sure your clients are aware of what's going on and beginning to think about So you have the form advisor. You have, I work with some agents and some brokerages where they have a policy that says, we're going to send this to you. We're going to send the whole agreement to you before we send it to you in a mechanism that you can execute. I work with some agents that they send that to them in a PDF. Then they get on a phone call and they walk through them, and then they go back after that phone call and say, I've talked to you. You now understand this. We can move forward. Did you have a question? Perfectly fine. The idea is creating that time, and then having it documented that you created that time. Because that time is what's going to create that presumption. Like you hand them that form agreement, and they've had it for a week. There's going to be a presumption. It's going to be hard for that individual to rebut the presumption and say, I didn't understand. You had it for a week. You're engaged in probably what is one of the largest transactions you're ever going to be engaged in your life. It does. It does. Yep.
just so for the people on Zoom, the discussion was over cars.
About is making sure that you have a record, getting that agreement to them. If you haven't worked with a buyer very long, maybe you hit the home run. You signed up the buyer on Thursday, you found a house on the MLS that you liked on Friday, you did the open house on Saturday, and magically you were in contract by Sunday? We don't see those anymore. Maybe that home run hit. You want to make sure you've got a mechanism to get that contract out and to show that the client understood it. I know with a lot of you guys, you're working with buyers and you're writing 15, 20, 30, 35 offers before you get one accepted because the competition is just so high. Make sure that you have that track record so that if that buyer ever raises a claim, you can say, look, we did like 40 offers. We went over this contract 36 times before we got a deal. You understood what's in. It's about tracking and creating that document trail to show that they understood what was going on. Ooh. Failure to retain records. Fortunately, there is great technology to help you do this. DRE has a rule or regulation that says that you're required to retain your records for 3 years. How many of you think that 3 years is a good time frame to keep records? Why not? You are 100% correct. Lawsuits can go longer. The statute of limitations on most of your claims is longer. How many of you know what the DRE statute of limitations for investigations on a complaint is? 6. 6 years. Imagine this. A disgruntled client comes back after 4 years, raises a DRE complaint, and you've destroyed your records after 3. How do you defend yourself? Terrible idea. Breach of contract is 4 years. Fraud, which is every negligent or every non-disclosure claim is predicated on fraud. It's a 3-year statute of limitations. Except it's not 3 years from the date you closed, it's 3 years from the date they figure it out. The longest statute of limitations I know of on a fraud claim that has survived is 17 years. It's called remote fraud. It was somebody 4 transactions prior who did something and passed the information down, and eventually a person 17 years later figures it out and goes all the way back and sued the first person. You don't need to keep it for 17 years. I've seen that once in almost 18 years of practice in somewhere north of 5,000 real estate claims that I've been involved in. Very, very rare. Yes? No. You can keep it just electronically, but you have to keep a file somewhere. The other thing that you have to think about, where's my little device? That one. You got a cell phone?
I've got a device.
Okay. So right now, you only have to keep the transaction documents and your correspondence, but your correspondence is defined as emails, letters, and so forth. How many of you communicate, let's say, more than 80% of the time with this thing? Text messages is where most of your communications are at. Technically, you don't have to retain text messages. The rule hasn't been expanded to cover that yet. I think it's going to happen because so much of the communication is happening that way. But for your protection, you should have that. We had a case not long ago where we were involved in, and thankfully we were able to get it and get it settled in a reasonable and amicable manner. But all of the problem and all of the condemning evidence was in text messages between parties. If it wouldn't have been saved, this would have been a disaster of a case. But that's how we were able to get some assistance and get a resolution done. So you want to be thinking about your records retention is bigger than just the emails and the transaction documents. It's every mode of communication. When you speak with a client on the telephone, have a follow-up email to document that. Because what happens is if you talk to them on the phone, guess what they forget when they bring the claim? The conversation. Memories are very, very short. And they're very, very one-sided. So one of the things you want to be thinking about is how do we protect ourselves? We're in this RPA. We're in the middle of this transaction. We've got some problems going on. We want to document that. We're going to have a phone call so we can try to appease this client, but we want to follow it up so that we have that record. That's what protects you, because the only thing that can protect you at the end of the day is the document. Because if you get into a courtroom, which is a lousy place to be, it's your word against their word. And you're the professional. You're the licensee. You're the one that the court's going to say knows better. So what we want to be doing is making sure we have that paper trail that follows. And it's a pain. It's not fun. You can ask all the associates that work for me, because I tell them, if you talk on the phone, follow it up. Send an email. Oh, well, it'll be fine. It's just a short conversation. They'll forget. California is a two-party consent state. So you can record, one, if your broker will allow you to do it. Number two, if you get consent from both parties. Because if you don't get consent from both parties, it's a felony. Don't do it. There was one other thing I was going to clarify.
With the records?
No. Any questions on record retention? No, you still got to keep it, because you started a transaction. You got to keep everything. Keep it all. Well, that's it.
You know what? There was one thing that I think we maybe wanted to talk about, and this is totally skipping around, sorry, but the mediation and attorney's fees.
Oh, yeah. Mediation is very important. We talked about how they broke it up to eliminate some of that confusion. We get a lot of times where clients are like, well, I don't want to go to mediation because it's going to cost me $8,000 or it's going to cost me $10,000. They still need to go to mediation. In the contract, there's a provision that says, not only is mediation mandatory, we have a really nice provision. I forget where it's at now. I think it might be in the definition section. I can't remember. But there's an attorney's fees clause. And in the RPA, the attorney's fees clause says that the prevailing party is entitled to their attorney's fees, reasonable attorney's fees, whatever reasonable means, I don't know. Reasonable attorney's fees if they prevail. Do not mediate. And you would have been entitled to your attorney's fees. You don't get them. Mediation is such an important thing in the contract. It's such an important thing from CAR. It's such an important thing in the real estate world and even in the legal community. I'm putting it in my contracts that I write in other industries because I think it's great. Mediation has a way to solve cases before they get expensive. So the contract says that if you don't mediate and you win, you don't get your attorney's fees. So when you have that question, when that dispute arises, this is not something that you get to tell your client. That gets us back to practicing law without a license. Here's how you do it. If they don't want to hire a lawyer, tell them to read the mediation paragraph very, very closely. If you would like to make it stupid simple, keep a paper copy, take a yellow highlighter, and highlight the language. And then just go, I think you need to read this paragraph. But they can't have a problem. Story time. About 7 years ago, we got involved in this big non-disclosure case. We were representing the good guys, not the bad guys. In that case, it's a $4.2 million home in Marin County with a water view. Yay. Plaintiff's attorney, I'm not going to do that. That might be blasphemous. Plaintiff's attorney, not thinking and not being a savvy real estate attorney, immediately files a lawsuit. Doesn't demand mediation. Doesn't do any steps for ADR. Big bad insurance company hires us. And we look down, and after we stopped laughing, we said, we're going to have fun. Got a hold of the insurance company, said, here's what they did, here's their problem. Big bad insurance company goes, do whatever you need. We litigated that for 5.5 years until we got to about 90 days from trial. And the plaintiff's attorney was telling us, well, if you lose, you're going to have to pay attorney's fees. At this point, we're talking between the two parties about $1.5 million of attorney's fees have been spent. Even if I do lose, I don't have to pay them. And they got into a fight. So we just circled that paragraph and highlighted that line and sent it back. Mind you, the plaintiff is claiming somewhere north of $900,000 of damages for non-disclosure. We settled that case 2 weeks later for a very low number, which I cannot say. The unfortunate thing for that plaintiff's attorney is he's now a defendant. One of the things that's important is you've got to make sure that you read and understand these agreements. Clients have to read and understand the agreements because at the end of the day, it's the client that gets harmed. So our job as lawyers, your job as real estate professionals, is making sure that even though they may have that hesitation, is getting them to the right professionals at the right time so that they can make the right decision. You notice I'm not saying it's always going to be the best decision or the decision in their interest. It's the one that they need to make based on the facts and circumstances that exist. There is one exception to filing a lawsuit without mediating. I'm going to tell a story on one of my attorneys. There is one exception in the contract. Every year, I go on a little trip for a weekend and have some fun. And I was on one of these trips. And my attorney, very smart guy, way smarter than I am, calls me in a panic. I'm on my trip, so I don't answer the phone. I let it go to voicemail. I listen to the voicemail, and he goes through. Keith, I don't know what we're going to do. I think I've committed malpractice. I've filed this provision. I already know what the case is about. I already know what the issues are. And I go, not a problem. I already know what's in there. So I don't call back. At about 4:50, my wife, who has the bat phone number, calls. She's like, so-and-so's freaking out. And I go, I know, freaking out over this case, right? Yeah. I go, there ain't nothing wrong. I know about the case. I know that the case was filed because it was about a week before the statute of limitations was going to run. I know that there's an exception for that. And she's like, well, don't you think you should call him back and tell him that it's okay? They won't learn. I need them to remember this. So no. Oh, it got bad. I show up Monday morning, very fine attorney, one of the better ones in our office, walks into my office and goes, I think I have to resign because I think I committed malpractice. And I said, you didn't commit malpractice. I said, the only thing you didn't do is you didn't read the agreement. Like, what? So if you remember the old version, the 2018 version, not the 2020 version, the 2018 version, you had paragraph A, paragraph B. Paragraph B ends, and paragraph C starts at the top of the next page. And he's reading through this. And I'm sitting in his chair, in the chair right across from his desk. And he goes, it's right here. And I said, so-and-so, is that the end of the agreement? And all of a sudden, the light bulb goes off. No, that's not the end of the contract. I said, yeah. So he flips over the next page. And the first two lines say that if you file a lawsuit for the preservation of the statute of limitations, you don't have to mediate first. You just have to stop the litigation at that point, preserve the statute, and then mediate. The contract. That's the important thing. So, like, if you listen to this, and we love being here, we love talking with you guys, everything comes back to reading that agreement. Read the documents. Every document that you stick in front of your client, you should know what it's about. You should have read it at least one time, preferably more, but at least once. He did. He even had the right language in the agreement that says this is filed for the purposes of preserving the statute of limitations. Just didn't read the next page. So if there's anything that I can impress upon you, read the agreement, read the agreement, read the agreement. You got to know it, because that's the way you're going to be able to save yourself from these pitfalls that we talked about, and that's going to be the way that you're going to have the upper hand in helping your clients navigate these transactions. I think that's about it. Any questions? No. It's the arbitration clause. Well, they don't have to. Buyer and seller don't have to sign the arbitration clause. But if both parties sign the arbitration clause, then they are legally obligated to arbitrate. If only one party signs the arbitration clause, you don't have a meeting of the minds. There's not mutual consent. So there's no arbitration clause that's enforceable. Bench trial. Bench trial. You're not going to get a jury trial on these very often.
Maybe we can hit on the difference between mediation and arbitration. Does everybody know that? So mediation is where there's, if say Keith is mad at me because I didn't tell him about half the house is falling down. And so we have Noelle is going to be our mediator. So there's no binding obligation if we do come to an agreement. She's just there to help kind of facilitate something that we both come to an agreement on separately, right, and figure this out. And so she's kind of talking to both sides, hey, maybe you should do this, maybe you should do this. So that's mediation. Arbitration is where both sides agree to letting the person who is the arbitrator make the final decision, and that decision they agree is binding. So in an arbitration, Noelle is kind of like a private judge that we've agreed to. And so that's the big difference between mediation and arbitration.
You pass. So it depends. So it depends. Like, if you look at the mediation provision, it references you to the car mediation panel. Some of those on the car mediation panel are retired lawyers. Some of them are active lawyers. Some of them are real estate brokers and agents that have a lot of experience. It just depends. A lot of times when we work with clients, we use professional, well, I shouldn't say professional. We use mediators who are lawyers and retired judges. And there's something to that, right? Like, if you get two parties into a dispute and they go to talk to a real estate agent, you may know the stuff really, really well. But there's a perception of not having that legal training. And so oftentimes, when we're engaged in these types of lawsuits or these types of disputes, we'll use like a Judicate West, or we'll use ADR, or we'll use JAMS, or some of the other large mediation firms in town that are comprised of lawyers and judges. Because sometimes having somebody be able to say, well, I was a judge on the Sacramento or the Placer County Superior Court for 25 years, and this is how it's going to play out. Sometimes that motivates people to settle. They may not be right. Yes. Maybe. I can give you the right information somewhere in the vicinity of 450 to 700 real estate cases every year. We do a lot. We have other practice areas, but we won't get into those right now. Yeah, and one of the things you can do is you can go onto our website. I don't know if we're allowed to plug ourselves, but you can go onto our website because we've written extensively on easements, and you can grab that, and it'll give you a lot of the information on how these decisions get made, because it's a very finely tuned legal framework on easements because it's been around for 120 years. Yeah. We do not. My predecessor retired, and when he retired, there was no need for that office because that office was 2 blocks from his house. It was an office of convenience. But we do have our main office in Gold River, and then we've got offices in a couple other states. So. Any other questions? Well, I don't know if he's lost yet because he's still a defendant. No. No, that attorney was a personal injury attorney who decided to play in a world that he didn't know about. So, yeah. Any other questions? This is usually where I say if you have questions, you should ask them because this is the last time you're going to get to talk to a lawyer for free. No, it's been a pleasure. You guys have been great. We'll hang out for a couple minutes. If you have questions, come ask us. We'd love to help you out.
I did want to just point to everyone to our website. We have a blog, and we post a lot of articles. And we recently did a few articles that are about the new real estate laws for 2022. So if you want to check that out, you can subscribe to it and get it by email, or if you want to just peruse the website and check it out, you can search too if you're curious about a certain subject. It's the blog on our website, bpelaw.com. Yes, sir.
So, you can check the boxes. I'm telling people just write it in because what's happening is, they're trying to get escrow to, when they say both or pay your own fees, they're trying to get escrow to make a determination of normal and customary fees in the locale. Is there such thing in this market? No, unless it's buyers paying for everything. Yeah. No, so you got to kind of go back to the old method and spell it out. 50-50 on this, buyers paying for this, sellers paying for this, they're splitting this. It's a little bit more work. I don't like that box, but that's what you got to do. What does both mean? Does it say that? Back in the top. Okay. Yeah. Perfect. I'm going to have to memorize this one again. Yeah. The each to pay their own is...
Yeah, which ones?
Does somebody have an agreement so I can take a look at it? Perfect. If both, okay. Yeah, perfect. It might be just a copy. So if you check both, it's 50-50. Make sure you talk with your escrow officer and make sure that's going to be fine. One of the things when we talk to escrow officers is they like to see a little bit more definition and a little bit more clarity. Speak up. Or, I can't hear. I can now.
I saw the guards are still out there, so make sure you get those surveys.
You have to be really careful because if that second party signs after 3 days, technically that contract can lapse and be null and void because it's accepted on time. But if the first party who signed begins to perform, that performance becomes a ratification. That make sense? Yeah. So, well, no, because well, yeah, because normally the buyer's going to make the offer and sign and send it. The seller comes back and the seller signs it 4 days later. If the buyer walks down at that point and puts the deposit in, they've got ratification. They've got performance. At day 4, so a counter offer is a rejection of the first offer, and it's a new offer that's made. So. You can do that, but they're probably not going to sign it because it's just you've rejected their whole offer. The minute you send that counteroffer and you change a term, you've rejected the entirety of the offer. So if all you're trying to do is buy more time, it doesn't really buy you any more time because you've already rejected their offer. They're free to go do whatever they want. Yeah. Clear as mud? The listing agent's not going to sign it. There's not a spot for him. Okay. Yeah. You can make an essential term. Yeah. No deal. No deal. If you want the arbitration. Now for like me, I'm going to tell you a story. About 4 years ago, I was looking to buy a house, and so I was getting into contract, and my agent sends the thing over to me, and I fill it out, and I don't sign the arbitration clause. Why don't I sign the arbitration clause? Because I'm a lawyer. It costs me $0 to litigate. I still don't like doing it. My agent calls me and says, Keith, you need to sign the arbitration clause. I'm going, no, I don't. Like, do you know what it's going to cost me to litigate if they do something stupid? $0. Actually, it's not 0. It's $435 to get in. And I've got 14 lawyers that work for me. I can do this. You know how much it's going to cost me to arbitrate? $10,000 minimum. I don't want to do that. So, but there's this perception, right? Because in most of these cases, because that little box is there to sign, most of these almost by default get initialed because that's kind of the industry standard. So the conversation that you have to have with your client and why it's important to understand the difference between arbitration and mediation is there's a significant cost that goes with arbitration. Arbitration is good because it's confidential and it's fast. You can get an arbitration done in about a year, maybe 16 months. Litigation, you don't have to pay the arbitrator, but you have to pay with time. In Sacramento County, it's taking us almost 4 years to go to courtroom. In Placer County, it's taking us 2.5 years to get a courtroom. I've got a case in Sacramento County that just got set for trial. It just went through the trial setting process yesterday. You know what my trial date is? It's March of 22 that we're at right now. My trial date is December of 2023. We're having cases in Placer County that are being set 18 months out once they get to the trial setting phase. So there's benefits and risks to both of them. Litigation is cheaper in the sense that it doesn't cost you to pay for the arbitrator, but it costs you in time. Oh, I don't care. I know how to get out of these contracts. I'll put a liquidated damage clause all day long. I also know that under California Civil Code section of 1641, if the liquidated damages isn't reasonable, I can litigate and get out of it. Plus, I put a number small enough to keep it in the small claims jurisdiction, and if I wanted to breach, they'd have to sue me in small claims, and I would have the upper hand. You can. I may not know the answer because I prepped for the RPA. Yeah, you can ask it, or come up afterwards. Did you have one? Yep. Yep. You're seeing it a lot, and in this situation, I'm telling people, document, document, document. Have those conversations and have that advice. Remind them and point them out in the contract where it says that removing contingencies and waiving these things at the beginning is against our advice, and laying this out. If you've got a little bit of time, which I know in your industry you don't, time is not a luxury that you have. But if you have a little time, get them in to talk to a lawyer so the lawyer can go, this is what will happen if you do this, because you waive this stuff on the front end unless the seller does something else to revive a contingency statutorily, you're stuck and your money's at risk. It's a bad idea. Talking about purchasing rental properties that have tenants. Yep. Well, it does, but what the seller is doing is I'm countering around that, and the seller's allowed to do that. And the seller, if a seller's coming to me, that's exactly what I'm telling them to do, because what we can't guarantee in this market, one, we can't guarantee that tenant's going to be out. Even if we give them cash for keys, we can't guarantee they're going to be out. And then the other problem we're running into is it used to be that I could kick somebody out, I could evict them in about 45 to 60 days. Right now it's taking, about 4 months to get somebody out, maybe 5. And so the problem is the sellers they've gotten smart because we've had this COVID wave going on, and we've had these issues with timing and being able to get people removed. And they're saying, look, we got a tenant in it. I can't guarantee what the tenant's going to do because we can't guarantee that the tenant's going to be able to find anything. So that tenant may hold over, and if that tenant holds over, I can't be responsible for it. But then you have no contract. You've got no deal. Yeah. 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 Mm-hmm. For months. And the thing that you have to be thinking about, sometimes what a buyer, so you can write it back. The seller says, look, we're not going to be responsible if that tenant doesn't get out. You go, fine. We're not going to hold you responsible. However, we're going to have the right to unilaterally extend the close of escrow time frame to give you the time to get them out. Yeah. Yeah, the big issue, that's a good point to bring up, is like take VA, for example. We had one of these during COVID where our client, very nice individual, buying a home, uses VA loan. An unscrupulous seller held over because that was back at the beginning when UD court was completely shut down. But under the VA regulations on the VA loans, you have to have that as an owner-occupied property within 60 days, and if you don't, they have the right to call it. And so we were able to get our client into the house. Basically, we sent a letter that said, you have to give us all the money back because we got the information that showed that the seller knew that they were going to hold over. They knew that they were going to use a medical excuse for it. They got it 3 days before close, and they never told our client. So eventually, I think it was about day 50 they got out. You don't normally get that lucky. So the one thing you got to be thinking about, absolutely, especially if you're using VA loans or you're using FHA loans or HUD loans or something like that, because they have an occupancy requirement, you have to think about, if this person's not going to get out, what kind of extensions can we put in to delay the close of escrow to make sure that our client's not going to jeopardize or have their loan called at a later date? I got a couple more minutes. I got a 2 o'clock, so I got about 2 minutes, and then I got to go. Speak up. Mm-hmm. Yep. So the market's kind of changed. Lawyers won't do it. Lawyers will help you draft the documents and put all the language together so it's done right. It used to be that there were a couple of smaller escrow and title companies around here that would provide the collection service, but I don't know of anybody that's doing it anymore. The risk and the liability is so high that a lot of the companies who used to do it won't do it. So it becomes a matter of the seller. If the seller's going to carry, the seller's going to play bank, collector, enforcer, all that stuff. You guys have been great.